Welcome to Breaking Ties, a new you after divorce. This is your go-to source for practical advice and support for when the divorce process has finished. Join us each weekday for a quick chat where we'll cover a variety of topics related to post-divorce. Together, we'll explore the emotional, financial, and legal aspects of life after divorce and help you find the best path forward for you and your family. Here's your host and Certified Divorce Financial Analyst professional, Mike Fulkerson.
Hi, and welcome back to another episode of Breaking Ties, a new you after divorce. I'm your host, Mike Fulkerson, financial advisor and certified divorce financial analyst professional. And today's topic is really a concern for many divorced parents, and that is child custody changes after a final divorce decree. I mean, we all know that life is unpredictable and circumstances can change. So let's explore under what circumstances a court might modify a child custody arrangement after the divorce is finalized. Generally, courts prioritize stability for children. I mean, this is the principle of stability that the court system uses. A final custody decree is intended to create a predictable environment for kids. So modifying this arrangement is not taken lightly. However, we do have exceptions where a judge might consider modifying custody. To prevail, you'll need to demonstrate a substantial change in circumstances that necessitates a change to protect the child's best interest. Let's look at a few examples right here. First, might be relocation. If a parent with primary custody plans to relocate a significant distance, it might impact the other parent's access to the child. Change in parents' fitness. If a parent's health, addiction issues, or living situation jeopardizes the child's safety or well-being, custody modification might be necessary. And then you have the child's needs and preferences. As children mature, their needs and preferences evolved. The court might consider a child's expressed wishes, depending on their age and maturity, and if it, still is in the best interest of the child through the court's eyes. Now, the burden of proof really lies with you. It's going to rest on the parent seeking the modification. And this means you need to convince the judge that the current arrangement is no longer in the child's best interest and that your proposed modification is a better solution. So as we look through the modification process now, it typically involves three things. One, filing a petition. I mean, you'll need to file a petition with the court outlining the reasons for seeking a change and your proposed modification. Then there's serving the other parent. Your ex-spouse will be notified and has the opportunity to respond with their own arguments. And then you could have a hearing. The judge will consider evidence from both parties, including witness testimonies and expert evaluations if necessary, before making a decision. You could also consider mediation before resorting to court. A neutral third party can facilitate communication and help you reach a mutually agreeable solution regarding, custody changes, and that could potentially save time and emotional distress. Now, this is a very complex legal matter, so consulting with an attorney experienced in child custody modification is probably in your best interest. They can advise you on your rights, the legal requirements, and the best course of action for your specific situation. So while modifying a child custody agreement after divorce is possible, it requires a significant change in circumstances and demonstrating it's in the best interest of the kid. Carefully consider all options, including mediation, before seeking legal intervention. I want to thank you for joining me on this episode of Breaking Ties, a new you after divorce. Should you have any questions on today's topic, just let me know or leave a comment. Divorce is not the end of your story. As we already know, it is the start of your next great chapter. Until next time, all the best.